Thank you, Madam Clerk. As you may have noticed, we had to go to the bullpen and bring in another judge for this case. Joining us now, to my right and your left, is my friend and colleague, Judge Ross Dyer of Shelby County, 30th Judicial District. Judge Dyer will hear the rest of the cases on today's grand panel. And he's been a member of this court for 8.5 years, which seems impossible, but it's true.
Yes, it does.
All right, Madam Clerk, please call the next case.
State of Tennessee versus Alexander Kim.
Good morning, Mr. Brayton. Good to see you. Would you like to reserve any time for rebuttal?
I would. I'd like to reserve 5 minutes, please.
5 minutes, yes, sir.
Sorry, it takes me a minute to get situated.
Take your time.
For the record, my name is Tony Brayton. I'm an attorney with the Shelby County Public Defender's Office. Here on behalf of Mr. Alexander Kim. Mr. Kim was found not guilty by reason of insanity in the death of his mother. He's been under a mandatory outpatient treatment program for some time now. We seek to end that program. That's why we're here. All the evidence in this case presented in 3 hearings over about a 2-year period favors that request. The state put on absolutely no proof whatsoever. Mr. Kim put on expert after expert after expert who testified that he was ready for this and to go on. In fact, Dr. Kim Lee Brown, a renowned psychologist from Vanderbilt, testified that Mr. Kim is a model patient, that if you designed a patient for the aftermath of a not guilty by reason of insanity, it would be Alexander Kim. In reviewing this, the court is supposed to look at the likelihood of harm if the treatment program is lifted, the likelihood that Mr. Kim would continue treatment without being required to do so by a plan like this, and his history of compliance with the plan and a kind of a catch-all is the 4th factor. All the evidence in this case shows that Mr. Kim poses little or no threat of harm to himself or anyone else. Every single witness who testified to that. Dr. Brown did a violence risk assessment evaluation and concluded that Mr. Kim's future risk of violence is low. Same thing that probably any member in this room, any person in this room would get. The state didn't call a single witness in any of the 3 hearings to refute any of this evidence and didn't really effectively cross-examine them to damage the evidence.
What's the state the trial court obviously talks about it, and the state talks about it in its brief. You obviously take issue with this relapses
I did
argument.
take issue with the relapses.
Can you explain that to me, please?
Well, I can explain what I think Judge Blackett was trying to say, because the reality is there were no relapses. There's no proof of any relapses. Prior to being diagnosed as schizophrenic and beginning treatment, in 2012, I think, he was a student in Knoxville and got prescribed Adderall by a nurse practitioner there. I don't know what her field was beyond that. Judge Blackett concluded that because he quit taking the Adderall, and he was also prescribed Abilify, which he didn't take, which can be a treatment for schizophrenia, but I'm not sure why he was prescribed it at that time, because it can be treatment for other things as well. She concluded that his failure to take those drugs led directly to his mother's homicide, which is just, I don't know where that comes from.
So he'd never been diagnosed prior to the homicide?
That's correct. Prior to this catastrophic event, he was undiagnosed and untreated. Since he's been diagnosed and began treatment, he's become a flawless patient. I mean, 100% compliant with everything. So I'm not really sure where she got all that from, and I hate to say she just made it up. I don't think she made it up. I think she just misunderstood.
Well, I mean, obviously there's some testimony about he didn't take the Adderall, but the Adderall had nothing to do with the current diagnosis. Right. He hasn't been non-compliant since he was diagnosed and has been in treatment.
That's correct. And I think the testimony about the Adderall came from Mr. Kim himself, and I believe Dr. Brown touched on it as well. What Mr. Kim said is it seemed to exacerbate the problems he was having, the delusions, hallucination, and he quit it. I mean, and it's not intended as a treatment for schizophrenia. It's a stimulant. I got to stay up and study all night drug, you know. There's no way you can conclude that it had anything to do with this. And then since being diagnosed and beginning this treatment program, every witness testified he's been 100% compliant. Every witness testifies that he posed little or no risk of harm to himself or others in the future. They also testified that Mr. Kim was likely to continue his treatment even if he wasn't mandated by a court to do it, which is one of the factors, the second factor they're supposed to look at. No witness brought anything to disagree with that. Judge Blackett simply concluded that he didn't put on any expert testimony, which of course he did, and she qualified several people from Generations Mental Health as experts. All of them praised Mr. Kim's efforts in this matter from the time they've been involved with him. His history of compliance with the program, which the state seems to argue isn't relevant, is of course relevant. It's a factor they're supposed to consider, and every witness agreed he's been 100% compliant. He's had no issues whatsoever. Taken all his medication, made all the counseling sessions, had no interaction with drugs or alcohol. He's been perfect. I don't really have a whole lot to say beyond that, except that, I think the evidence is overwhelming.
The trial court, according to your brief, made a statement that no one could guarantee that he would continue his treatment, continue his medication. Is that, do we have to have a 100% guarantee?
Well, there's no one who could give you that guarantee. And if no competent medical expert would testify, I guarantee you he will always take his medication or he will never commit another act of violence. Dr. Brown explained that in that context, she wouldn't give that guarantee for you or me, The best you can say is they believe he will, and they have good reason to believe that because he has more than a 10-year history of total compliance with the medication. So,
Mr. Brayton, this plan, of course, involved him moving to Louisiana to reside with a friend. To what extent, if any, did Judge Blackett express any reservations about him moving out of state? Was that a topic at all in the trial court? It
was a topic initially, and he sought the interview down in San Antonio is where he actually wanted to go.
I'm sorry, I apologize.
That's fine. Same thing.
Down that way.
Yeah, it's not here. She had some reservations. She wanted, I think, ideally to transfer the mandatory outpatient, but it's not legally possible to do so. We had initially requested a 2-week period to allow him to leave Memphis and state of Tennessee to go down to San Antonio, where he had made connections with mental health providers down there. He had identified pharmacies where he could go, and he was going to seek employment. She initially okayed it for 1 week, which is clearly not long enough, and then she denied him the right to go altogether. And so we sought to end the plan completely.
Given the practical difficulties that could arise if he was out of state and became non-compliant at that point, and also given our standard of review here, which as I understand it is de novo with a presumption of correctness, from your perspective, how do you overcome a presumption of correctness given those reservations and issues?
Well, I don't think she's entitled. I don't think we do this de novo with a presumption of correctness because the order itself is based on facts that don't exist in the record or twisting of facts that are in the record. When you conclude that the Adderall led directly to his mother's death, that's just preposterous, and there's no proof to even suggest that. And there are other things. She said he would rapidly deteriorate if he didn't take his medication, and there's no proof of that either. In fact, Dr. Brown testified that deterioration, if it took place at all, would take a period of at least several months, perhaps longer. So I don't think she's entitled to a presumption of correctness here. And I think that's how we overcome that, since the order isn't based on what was the proof in front of her. So, I think the only thing I can say, and we came to argue today because I wanted the court to understand that Mr. Kim is a model patient. That's how everybody described him. And if he can't get relief, I don't know how anybody could. So, unless there are questions, thank you.
Thank you, sir. Mr. Douglas.
Morning again, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the judgment of the trial court here because the trial court did not err by declining to terminate the defendant's mandatory outpatient treatment program. What the court did was it properly identified the relevant 4 statutory factors. It considered each one of those, it applied them to the defendant's case, and those findings are in.
How is him not taking Adderall prior to a diagnosis some sort of, how does that meet the factor that he won't take his medicine now when he's been taking his medicine for 10 years?
I think it was relevant for the court to consider just as evidence of him being previously diagnosed with a condition and prescribed a medication that he willingly chose not to take. I think it's absolutely part of his sort of medical history, and it was a relevant consideration for the court to make. I know there was some discussion too about the use of the word relapse, and the court issued a really lengthy order, ultimately denying the motion to terminate. And I don't think the court actually, while it used the word relapse.
Or used the word relapse. You can't say it didn't mean it. It used the word.
I think what it was really trying to get at was its concern that we saw the symptoms that the defendant had when he was not medicated for schizophrenia, and the court's ultimate concern was that terminating the MOT could result in him stopping his medication, which then could lead to the return.
So let me then go to Mr. Brayton's last statement / question. If someone who's been completely compliant for 10 years, who every medical expert says, this is the candidate, if you can't release that person, who can you ever release?
I think here the statute.
And your only relapse is something before he was ever diagnosed for a medication that is not part of the protocol now.
No, I certainly understand the concern, Your Honor, and I think the statute, it does intend to treat crimes like first-degree murder and other Class A felonies separately from all other crimes. The statute specifically refers to first-degree murder and Class A felonies when it requires a trial court to apply these 4 factors that the court applied here. And that last factor is a really broad one. It's I think both parties agree, it's kind of a catch-all factor. That's not something for the court to apply, though, unless it's, again, a crime of first-degree murder or a Class A felony. And while there certainly was testimony that Mr. Kim had been a model patient, I think it was relevant information for the trial court to consider the fact that he committed a homicide when he was undiagnosed and unmedicated with schizophrenia. If the MOT was terminated, there would be absolutely no required supervision. Even some of the defendant's own witnesses testified it would be extremely difficult for him to actually be treated if the MOT were terminated and he was having a mental health episode. And I think it was, again, something the court really focused on was just we have concrete evidence of the harm that comes if the defendant is not medicated. We have evidence that while it was years and years ago, there were 2 separate occasions where he was prescribed a medication and he himself just elected not to take it. And without the MOT, there really was no guarantee other than his assertion and the beliefs of some of his witnesses that he would continue to take the medication, and his own personal assertion that he would take the medication is not the relevant inquiry here. What this court explained in State versus Baumgartner regarding the likelihood that the harm will occur unless the person remains under court-ordered outpatient treatment, it doesn't at all deal with the patient's personal desire to keep taking the medication or personal assertions that he or she will keep taking the medication. Instead, the inquiry is the likelihood of deterioration in the absence of treatment. Another thing the trial court reasonably focused on here was almost all the witnesses testifying that if the defendant stopped taking his medication, it was likely that his symptoms, including delusions, which led to the death of his mother would return if he stopped taking the medications. And that's exactly what was at issue in Baumgartner. There was a medical professional who testified that Ms. Baumgartner's symptoms were likely to return if she stopped taking her medication, and that she was likely to deteriorate quickly. You had Phyllis Taylor here testify that if the defendant stopped taking his medications, then the effect could wear off rather quickly, and that would lead to the return of symptoms like delusions and paranoia. So the trial court here had concrete evidence of the likelihood that symptoms would return if he stopped taking his medication, and the court reasonably focused on the potential harm that could happen to someone in Tennessee or someone in Texas. I think that was another real concern of the trial court, that the defendant would be out of state and that there would really be no way to keep him supervised and to keep him medicated without this MOT in place. And again, based on the seriousness of the crime for which he was found not guilty by reason of insanity, the statute really contemplates that there's a different standard to apply to a crime like first-degree murder. It specifically sets forth that catch-all factor, which is any other factor that the trial court deems appropriate. And so here, the trial court really reasonably focused on the potential harm that could come. And it was the court's findings are entitled to a presumption of correctness and reasonableness here. And based on everything that was in front of the court, it did not err by deciding not to terminate Mr. Kim's mandatory outpatient treatment program.
Mr. Davis, this case presents a something we just don't see that often. Would you agree with that?
Yes, Your Honor.
Are you aware of any case? I know you only cite 2 cases in your brief. One of them's the Baumgartner, just to tell us what our standard of review is pretty much. But are you aware of any case where the state appealed a court's grant of a motion to terminate a plan, outpatient plan?
Off the top of my head, I'm not entirely sure if I'm aware of a case where the state actually appealed.
Are you aware of a case where this court or any appellate court reversed a trial court's denial? I guess what I'm getting at, this is a fairly unique situation that we are looking at in this particular case. Isn't that correct?
Yes, Your Honor, it is. There was unfortunately, I could not find much case law out there.
And I guess to Mr. Braden's point is, what mental health professional is ever going to testify or guarantee? Oh, I can tell you this defendant will never commit any other crime. I mean, really, it does kind of put a person perhaps like Mr. Kim in a spot where he may be an appropriate candidate, but if we've got to find some mental health, or the trial court's got to find some mental health person, it kind of puts a heavy burden, if not impossible. Would you agree with that?
Yes, Your Honor, I would agree that it's a heavy burden, but I think that's what the statute really contemplates for, again, crimes of first-degree murder and Class A felonies.
And there is very little case law to help us with this, correct?
There is, unfortunately. Baumgartner was the most, I think, on-point case that I could find where the court was actually considering whether to terminate mandatory outpatient treatment program. But with Mr. Kim and the experts saying that obviously they can't testify with 100% certainty that he wouldn't relapse, I think what that really goes to is sort of the amount of time that he had been on the mandatory outpatient treatment program. The court was concerned about the fact that I think it was about 8 years had elapsed. The court was concerned that that wasn't necessarily enough time. And so I think that's sort of the factor that...
Well, I mean, enough time, I mean, back to Mr. Braden's statement and Judge Easter's question as well, I mean, you're never going to get an expert to say with 100% certainty this. It can be 5 years or 20 years down the road in the plan, No medical expert's going to say, I'm 100% certain this person's going to take their medication and stick to the plan. And the statute even just says likelihood. It doesn't say guarantee. It doesn't say, so it's almost, as I read, and I haven't read the trial court's order, but in reading the briefs, that the trial court set a standard that's not actually in the statute. The trial court expected 100% guarantee, and that's not correct.
No, I certainly understand the concern, Your Honor. I don't think, though, that the trial court was requiring a 100% guarantee. It was just simply considering the expert proof along with the concrete evidence of what could happen if the defendant stopped taking his medication and the relatively short amount of time that he had been under the mandatory outpatient treatment program. And the court applied these statutory factors to conclude that right now was not the time to terminate it. And again, I do acknowledge that this is a unique case. This is rare. There's not a lot out there on it, but what the court did here was reasonably identify and apply the correct statute. And unless there are any further questions, we would ask this court to affirm the judgment of the trial court.
Any questions? Thank you, sir.
Thank you.
Mr. Brayton in rebuttal.
You're right, there isn't very little case law. I suspect most of these things are handled by agreement, that we agree it's time to end this, so it doesn't get to this point. But as far as Baumgartner goes, there are some glaring differences between Baumgartner and Mr. Kim. In Baumgartner, every mental health professional who testified that Baumgartner needed to be under the supervision of a mandatory outpatient treatment program. And additionally and significantly, Baumgartner had a demonstrated history of what happens when he failed to take his medication. He apparently had been prescribed 2 antipsychotic drugs. Somebody substituted an antidepressant drug for one of those drugs, and within a few days, there were catastrophic results. Somebody was killed, and I think he tried to kill somebody else. That's the difference between Kim and Baumgartner. Mr. Kim has nothing like that. He is, every witness agreed that he was very likely to pose any risk of harm, and they just haven't met their burden. They have to show that his mental illness, his condition is likely to deteriorate rapidly. There's no proof of that, and result in substantial harm to someone else or himself. So there are some glaring differences between Baumgartner and Kim. Unless there are any other questions, I'm going to limp out of here.
Thank you both.
Thank you.
We'll take the matter under advisement, issue an opinion shortly.